collegially speaking, with me, Tarun Nangia. Today, we're going to discuss the topic of enforcement of arbitral awards, the arbitral process, and time is of the essence. What is the utility of time in the process during arbitration and during the enforcement stage after Section 34, and then when the judgment has been delivered right up to the Supreme Court, the time taken, the processes, the hurdles, and its impact on investment in India. That's more important because all this has a direct, indirect impact on India as an investment destination. Because today we want a lot of investment in greenfield capacity in India and also infrastructure. And all this inevitably leads to ADR and arbitration. And that is why we discuss this today. I have with me uh, Dr. Sanjeev Gemawat. He is the Group General Counsel of the SR Group, but more importantly, he generally speaks in his capacity as a founder member of the General Counsel Association of India. It's one of his brainchild. Good to see you, Dr. Gemawat, again, and looking forward to your insights. Uh, I have with me
Thank you, Tarun.
I have with me Senior Advocate Percival Bilimoria, who joins us from the city of Delhi. He is an advocate at the Supreme Court of India. Also does a fair bit of arbitration, international and domestic, both. Good to see you, Mr. Bilimoria. Thank you for your time. I have with me Neeti Sachdeva. Neeti Sachdeva joins us from the city of Mumbai. She is Registrar and Secretary General of the Mumbai Center for International Arbitration. She's done a lot of work for promoting the cause of arbitration in India. Some big ticket arbitrations are there in Mumbai. Uh, Good to see you, Neeti, and thank you for your time. I have with me Advocate Siddharth Sharma, who joins us. He practices at the Madhya Pradesh High Court at Jabalpur and also at the city of Delhi now, where he's been practicing since the past year or so. He will also bring his expertise on the subject. Good to see you, Siddharth, and thank you for your time. Uh, at the outset, let me request Dr. Sanjeev Gemawat to give the opening comment on time is of the essence. In fact, I know this is Senior Advocate Bilimoria's favorite topic. He would have brought this up with me at least on a dozen occasions in the past 2 years or so. So I think this will be a good interaction and exchange today. Over to you, Dr. Gemawat.
Thank you very much, Tarun. Thanks for inviting me. I think you always raise, contemporary and relevant topics, and particularly which are, relevant for the business and the corporate world. So I'm grateful to you for, raising these issues. As regards the time is essence, what we are talking, Tarun, is that we are talking about the corporate and business world. And corporate and business world cannot wait in perpetuity for certain matters or for a longer period of time, because as it is generally said that justice delayed is justice denied, and particularly when that gets applied to business and the corporate world, what we need to be understanding is that the whole delay process is impacting the economic growth of the nation. I think that needs to be perceived from that standpoint. But then, having said so, Tarun, I must say that the legislative framework is in place, particularly post 2015 amendment in the 1996 Arbitration Act. One is, of course, there is very limited grounds of challenge of the arbitral award. And when the award goes for enforcement, now there is no automatic stay. Normally, from a legislative intent standpoint and legislative changes standpoint, I think the law is sufficiently, providing those framework. But then, having said so, under one pretext or the other, enforcement, gets delayed, and there are multiple reasons of, all these delays. And those, of course, in subsequent, discussions, we can raise those issues. But then the multiple reasons are that the parties at times, or the execution, raise those issues which are not to be raised. Those all Section 34 related issues or challenges to the arbitral awards, etc. All those issues get raised. The second important aspect is that at times the location of the assets of the counterparty or the respondent At times, the discovery process gets delayed. If the party, the claimant is aware about the assets, bank accounts, etc., then the attachment is possible immediately. And if not, the whole discovery process gets delayed. The third thing is that at times counterparties keep on innovating and experimenting in terms of creating one or the other encumbrances on those assets. So that also creates a lot of confusion. So there are multiple ways in which the award gets delayed. But having said so, I think we are perhaps in a better world in terms of the awards are now getting considered and then executed and enforced also, particularly from the foreign award standpoint. I would say that there's a positivity in terms of the execution and the enforcement, and courts are very focused in terms of execution of the award. So this is what my preliminary comment would be, Tarun. Yes.
Thank you, Dr. Yemawat, for that opening comment. I go to Senior Advocate Percival Bilimoria for his opening comment.
So, Tarun, enforcement is a big issue in India. And I think, we've been, as a jurisdiction, roundly criticized for this. And I think justifiably so. Again, as, Sanjeev mentioned, prior to 2015 Amendment Act, there was no, there was an automatic stay the moment you file a challenge to the award. Now that is gone, because Section 36 now expressly says that an award is on the same footing as a decree of a court. So to just to echo what Sanjeev said, I think he covered it all. But the legal elements in the act are well in place. There's also a section 34(5) which lays down a time limit of a year. It's a statutory provision, but I think it was in one of Justice Nariman's cases where he said that it can only be directory. It's not mandatory. And I think rightly so, because the practicalities of getting a matter listed. So nowadays there is so much backlog. If you have a date today on a 34, right? And for some reason there is a continuance, you will probably get a date 3 to 4 months later. And this is despite the fact that it goes only to, a bench hearing only arbitrations. So whatever that could be done procedurally and legally has been done. I think it's really a question of two things to my mind. One is we need arbitrators who will articulate the award properly. See, there is the many innumerable decisions that say that a decree must be enforced uh, as it is. I mean, the execution court cannot go behind that decree, and we applied it in execution proceedings. But sometimes if the award is worded so vaguely that there is nothing that can be done. I mean, neither of the parties disagree on what it says, and the execution court cannot go behind it. So we need, first of all, awards to be properly written and articulated with a great deal of clarity. And then there is, of course, the fact that Section 47 of the CPC lays down certain objections that you can take at the stage of execution. Now, of course, there was one case in 2019 where I think Sanjay Agarwal versus Rahul Agarwal, where the Allahabad High Court said that, okay, it's at the stage of execution, now it's too late to bring in the objections of Section 47. We, of course, have the example of the case of Vijay Karya in Bombay, where, the Supreme Court confirmed that, violation of FEMA is not a matter of public policy. And yet, this was, I think, sometime in 2020, when the Supreme Court set out this principle, that matter is still going on. So, what is going wrong? It's essentially the backlog of the courts. It's also the fact that the counterparty will take every possible objection, all that they are doing is kicking the can down the road. Now, and mind you, at the end of the day, there is a heavy price to pay because they have to bear the interest also. So, I think in a way, the bar also has a responsibility to advise their clients properly and say that, okay, this is not going to come to anything much. You'll end up paying more interest. Just deposit the amount or make good the payment and then let it go away. Focus on your business going forward instead of dragging this on in court.
Point very well taken. Thank you for this opening comment. Done a lot to further the cause of arbitration and ADR in India. And of course, you also sort of now the center is doing well with so many arbitrations. Could you give us a rounded view on time is of the essence and the issues thereof? And somebody who feels, because you devoted your whole career to the cause of arbitration, so I think you would be able to better enlighten us on this issue. So over to you for your opening comment.
Thank you, Tarun. Thank you for having me. And let me first comment on the topic itself, on the enforcement, because there the MCI is not involved per se, and then I'll come to your question on MCIA. So I think I pause and look at a question, a simple question. When does really an arbitral award actually matter? Not when it is signed, not when it is published as well, but actually when it is enforced, right? And this saga of enforcement, if you look at, I think I would say for somebody who's an arbitration enthusiastic in the field, 2010 was really a time when we looked at the White Industries case. And that was, put mildly, I would say, was a big slap on our court system, on enforcement itself. So if you look at what happened in White Industries, there was this case, a foreign investor who had an arbitral award in its favor, went to Indian courts to enforce, and nothing scandalous happened, right? But what happened? That there was delay. There was a delay to enforce for 9 years. And that became a ground for an international law violation and a first BIT filed against India because India delayed the enforcement. So imagine, here we are not talking about a case where there is legally anything wrong, per se, but a delay in court amounting to an international law violation and a BIT being filed against us. And where have we come from 2010? Of course, I'm not a pessimist, and I love Dr. Gamawat always saying that we have done this, but we are doing great, right? We see Vijay Karya case, there is Docomo case, there is City Cruise case. Courts have come heavily as well. Foreign arbitral awards are being enforced and all. But there is still a lot to be done, right? But this is not the India story only. You look at the longest running arbitral award in the history of arbitration is UCOS case. Russia involved, right? An award which has still not been enforced, 15 years hence? So it's not only an India story, I would say. It is a difficult story, and I don't want to hide behind the scene to say that everybody else is doing wrong, so we are okay to do it. That's not the point. But yes, there's a lot to be done. Let me very quickly count on the other side of it. I always say there are two stages to an arbitration. One is to get your award, and second then is to see the money on that award, right? I think the legislative policies, if you look at institutions like MCIA, and I would say arbitrators to a large extent in India now as well, are very conscious. And we see that we reach the arbitral award in a considerably decent time now. MCIA published its report of 2025 cases, and we have published a data to say that on an average, we have taken 16 months and 20 days to complete arbitration awards, and these are not emergency arbitration. So I think as an institution, we are now doing the work. Arbitrators are doing their work. I would say parties, lawyers, everybody's joined to make sure you get your award. But if the client doesn't see the money there on enforcement, then I do not know really how much the arbitration system can change around it. So we need to reflect the post stage now. We've covered the one stage, I would say.
Very, very rightly said, Neeti, that the post arbitration scenario is grim, so to speak. Taking up to a decade also sometimes, maybe more, for the promoter to see the money. Something needs to be done. I think in the recent times, I'm right thinking people have come into the judiciary in terms of looking at arbitration enforcement with the kind of seriousness it deserves. I think that will make the difference. I'll go to Advocate Siddharth Sharma for his opening comment.
So, in fact, the first comment what I will make, I will borrow some hints from the statements made by Ms. Neeti and Mr. Percival. Vijay Karya has been cited twice, so I'll do the honors of citing it for the third time. And for a reason that in Vijay Karya, 50 lakh rupees cost was also imposed in that case. Now, it is a very important factor because it was one of the cases where the court actually noted that there are more than 4 awards already. There has been so much of litigation, and to compensate the other party, that particular cost has to be imposed. So, this is in fact another way of the courts dealing with the constant attitude of certain litigants, which is the case pe case attitude. We have all seen that Hindi movie scene where the actor says Tariq pe Tariq, but now we are dealing with a case pe case kind of a scenario in everyday lives. Now, there are two reasons for that. First is the textual premise of the act. So 3437 ensures that the case goes up till the Supreme Court as a matter of statutory right available to a judgment debtor. Second thing is that because of the huge backlog of cases, it was also observed by the Supreme Court in Chopra Fabricators that 30,000 plus petitions were pending in the state of UP itself, wherein the court was pleased to summon the record. So, looking at the huge backlog of cases, we have a practical problem also. So, how to deal with it is that what Mr. Bilmoria was also saying, that it is a lawyer's duty to rightly advise the clients. In fact, on the other side also, it is a lawyer's duty to constantly take the details from the clients as to find out the urgency involved in the matter, to constantly mention a case, to constantly request for early hearing, because that is the only way to deal with this kind of a legal framework and a practical reality of so many cases. So lawyer's role is very important here, and as well as a litigant's role. A person cannot just think that, okay, we have filed a case for execution and we can take a back seat and it will take its due course. Every hearing has to be followed up, and constantly the case has to be mentioned, and efforts are to be made to appraise the court of the urgency involved. Because like time is the essence in the enforcement, what Mr. Gemawat was also emphasizing on the financial aspect, because the money that is due today can be invested into a business opportunity right now. Maybe 10 years down the line, it can have a certain interest as a compensation, but the opportunity missed with that level of capital can also be once in a lifetime opportunity which can never be compensated. So with this, that's my case.
Point well taken, Siddharth. I'll go to Dr. Sanjeev Gemawat. Dr. Gemawat, one thing whenever we discuss with promoters, they say, Tarun, that there are jurisdictions and there are jurisdictions in the world. And today I have the capability and the independence to invest in different countries. Why would I risk my capital in a country where if there is a dispute, I won't recover for a decade? It's a very fair comment to make, don't you think so? And what do you think the courts, especially jurisdictions like Delhi, could be doing? Because a lot of commercial work ends up here. Arbitral enforcement also ends up here. Any wish list you have, because you also represent the general councils. So because you are also at the beating end, you are answerable to the promoter in many cases. And what do you answer if these things are beyond your control? You cannot sort of have a magic wand for the promoter to see money. But obviously they will call the GC and ask what happened. We won the award, but where is the money? Do you have a wish list that these 2-3 things should be done with immediate effect so that we don't suffer as a country and investments don't suffer?
No, I think Tarun, you raised a very, very relevant and important, question, and I would say the answer lies not at the time of enforcement of the award. The answer lies in the whole chain of events from the very inception when you finalize your arbitration clause. Let's understand this, the whole ecosystem of the whole chain of things. It's not only limited to enforceability. Why? We refer disputes to arbitration for largely 4 reasons: time, cost, certainty, and enforceability. Now, it's not necessary that once, and this is what the understanding is, that once the award comes, it essentially means that the finality has attained. But then if the issues are pending at the enforcement level, then again you are getting into an uncertainty. Now, why all these things get delayed, and I will be giving you the references of both the domestic issues as well as the outside jurisdictions also. We need to be very careful while drafting the arbitration clause that what seat we would be looking for. The seat of the arbitration would certainly be governing, and particularly when you are dealing with the cross-border transactions. Now, if you are finalizing a seat and where you know for sure that the counterparties, all assets are located in that very seat and that very jurisdiction, seat or jurisdiction, whatever, now your approach of arbitration clause while drafting should be very different. Now, if even in the domestic issues, if you notice, if as a claimant you are clear that the counterparty has assets in this particular location and you can trace those assets, you need to be very clear from the very beginning. Your enforcement would be effective. Now, why seat also becomes important? One is, of course, that as far as the enforcement part is concerned, you would be going to that particular location where the assets are lying. But then first, you need to be knowing where the assets are located, and accordingly, you can take action. Now, while drafting the clause, if just to give you example, like for example, my counterparty is based in Dubai. I know that all his assets are located in Dubai. If I want to make a claim against him, that is the only jurisdiction where I can enforce that award. Now, in that situation, why should I not be relying on those credible institutions in Dubai for enforcement of the award? If I take some other jurisdiction as a seat for my arbitration, and then I would be facing first the challenges in terms of recognition of that very award in that respective jurisdiction. So there are multiple ways of dealing with that situation. But then again, coming to your basic question, that whether if certain things are in your control, certain things are not in your control. Of course, it is true. But then, having said so, I would certainly say, and we have all experienced this, at times you need to be pushing for this, as Siddharth did mention about this, that the party should also be focusing on this, that once the execution is filed and you are just forgetting about it, it doesn't happen. You need to be pushing your application, you need to be filing earlier hearing application, and I think there are multiple ways of doing this. But largely I would say, Tarun, your credentials and the assets location of the counterparty is very important. You need to take the interim orders also at times, that he should not be transferring those assets for here and there and creating one or the other encumbrances, so that the whole issue gets complicated and your enforcement gets delayed.
Thank you for that informed comment, and you shared also the dilemma. I'll go to Senior Advocate Percival Bilimoria. Mr. Bilimoria, you work both sides. You also do your arbitrations. You argue. Also, the challenges right up to the Supreme Court. You've been involved in many. Could you take us through the problems that the business community India is facing, and if you had a wish list of 2, 3 things that can be done, at least one thing we could start with to ensure that the enforcement timeline is shortened and the promoter sees money quicker?
Tarun, like I've already said, it's the law and everything is all there. Uh, for example, quite apart from the law, the Supreme Court in at least 2 different cases has said that execution petitions must be settled in 6 months on 2 separate occasions. So I don't think I have a wish list. I think, to take off from what Sanjeev mentioned, the choice of jurisdiction is very important. Now, here I must tell you that off late, this whole controversy about interference by Indian courts, at least when it comes to a foreign award, I find that now the Supreme Court is very quick to dispose of foreign, disputes in respect of foreign award. Now, when you have a foreign award, it's really a situation where the court is looking at enforcement against residents in India. And, when you talk about the scenario where there is investment in India. So if you're talking about, say, joint ventures, any kind of a dispute there, the parties, I think, would naturally have their assets in India more than anything. So I think uh, there's a roadmap right there, which is that if you have a jurisdiction outside India, and it's a foreign award, and then when there is a question of enforcement, I think it is far more easier than getting a domestic award, which is challenged under Section 34, that where a lot of rigmarole is sometimes involved. I would not like to go any further because remember, there's the other side of the coin. There are certain awards given which are blatantly wrong, patently illegal, and those also need to be set aside. So I think there is a need for a balance. Uh, One major issue that I would like to say is that please opt for an institution, an Indian institution. We have MCIA, we have one or two other, very good institutions in India uh, who will then, have their own rules regarding the way arbitration is conducted, the speed in which the award is delivered, which is also a factor, as Niti pointed out. So if it is a domestic arbitration, I think opt for an institution. If you are an investor in India, the Supreme Court is much more liberal now, especially in interpreting, public policy. At one point, it was called an unruly horse, and there was a lot of delay. I think now the pendulum has really turned the other way. So I don't really see too much of an issue from the perspective of a foreign investor. So the days of white industries are now, in my view, over.
Point very well taken. I'll go to Nitin. Your first answer, you said that the problems generally we see the post arbitration process. The arbitral problems are largely over. You're seeing awards in 16 months, which is very good to hear and heartening. Uh, but you also know that as part of the larger process of ADR, things don't really end until many times it goes to the Supreme Court. Do you think this is an India-specific problem that needs an India-specific solution that our the judiciary can come up with? Do you have any suggestions to this end? Because once through a large arbitration, and when you don't see money for a decade, you may think before you commit money to this jurisdiction.
I mean, yes. Unlike Percy, I may have a wish list, which I would hope that somehow it gets implemented. And let me put it, three of them really. What I would say first, I would say is real costs. I think our courts now need to get a little more strict and impose costs where they know that a party is just unnecessarily delaying things. That I feel would be a big deterrent for all those sort of vicious litigations that we see in the court, people trying their hand at different levels, at different stages of taking it up all up to the Supreme Court as well. That is my first wish list, that we should see real costs from courts now imposed on parties. Second, I think is that we Indian party, I'm talking about for the Indian party especially, I would say that we are still not very used to having asset tracing companies being used. We know that there are specialized agencies, there are specialized asset tracing companies now who are only working in this field to get your asset. Sanjeev said a very good point that while you're contracting itself, I think it's important to know that if a dispute was to arise, where the assets are, and choose your seat wisely in that respect, right? I mean, you may end up enforcing your award outside of the seat in most of the situations, but a well informed getting into a negotiation, entering into a contract is always a good thing. So, where the Indian parties earlier shied away from having experts in their arbitration, and now we are seeing experts being used for damages, for construction, I think the time has come for us to use asset tracing companies as well. I think the third one I would say is more, which is more generic, to say that if we could have specialized commercial benches only for enforcement. Percy is absolutely right. If you look at foreign awards, our courts are now very quick. I don't think we have really denied any foreign award enforcement in the last decade. If you look at it, it may have taken a fair bit of time, but we have been very, very restrictive on our public policy. Domestic awards, I think we can, of course, make them better. But Tarun, let's not forget one thing, right? Sitting in a drawing room like this, having a discussion like this, are we talking about courts only in Delhi or Mumbai and enforcement's happening there, or maybe Supreme Court? Let's not forget that there are enforcement applications pending in maybe, what we call them as tier 2, tier 3 cities, in district courts as well, where the courts are not aware of the commercial matters sometimes, and it takes a long time there. So it's not that everything is bad, it's not that everything is hunky dory, but we need to also distinguish and see that, do we need to pull up some jurisdictions a bit more? Have those more training programs for enforcement for our judges as well? The National Judicial Academy needs to take up something at that level, I would say. Whereas I would say Delhi, Bombay, Supreme Court have fairly been conscious and acting upon it diligently. But cost is if out all of this, I have to say one wish list, I would say real cost is what now the parties need to see.
Point very well taken. I'll go to Advocate Siddharth Sharma for his comment.
See, as far as foreign companies are concerned, we are seeing a one unique pattern since the past 1 year. The FTA with European Union has been signed. The FTA with UK has also been signed. So the bilateral ties of India are constantly increasing. Now, when we look at a foreign investor compared to an Indian investor who first looks at the Indian states, maybe 29 states, a foreign investor looks at more than 100 countries so as to invest. So when that money is invested, the security of that money is a very big issue. As far as foreign awards are concerned, it has been taken care of up till a great extent. But as far as the domestic awards are concerned, and even some foreign awards, I just have one suggestion that we can learn by the example of MSME. Now, under the MSME Act, there's a condition of pre-deposit. Now, what this condition of pre-deposit does, suppose if there is a person who has challenged the award, so he has to deposit 75% of the amount. So it means that the person who is contesting the litigation by going for an application for setting aside, even he is at the receiving end. It is not just the person who has a favorable award because his money is now deposited. If something like this can be worked out in the Indian system, where a unsuccessful litigant before an arbitral tribunal is also under some kind of a compulsion to deposit or at least get some kind of a property attached, then it will lead to an urgency wherein both the sides are constantly pressing for the matter to be heard. And it won't be a one-sided effort as it is right now in most of the cases. So that is my one suggestion, either through a statutory framework or maybe persuading the courts to take up such a call.
Point very well taken. So that's it for today. The interesting bit of points made on today's show. On the next one, of course, we will delve into this topic some more. But I would like to thank Dr. Sanjeev Gemawat, Group General Counsel, SR Group, and founding member of the General Counsel Association of India, Senior Advocate Percival Bilimoria, Neeti Sachdeva, Registrar General of the Mumbai Center for International Arbitration, Advocate Siddharth Sharma. Appreciate that you could make time for such an important issue that concerns investment in India, because we may look at it as an arbitration. Business community looks at it as a metric to decide whether we should invest in a country where your all job creation, your GDP goals, everything aligns in the end to how your judiciary functions. That's why we take this up. Appreciate you joining us. Thank you so very much.
Thank you.
Thank you, Tarun.
Thank you very much. Bye-bye.